Welcome everyone to our webinar on self-represented litigants and family violence, making a difficult experience even worse. Look at our next slide, please. Just a moment to reflect the lands that we're on. All of you are here from coast to coast to coast. So we want to think about the traditional lands that all of us are currently situated on and join us in acknowledging and thanking the generations of Indigenous people who have cared for these lands and in celebrating the continued strength and spirit of Indigenous people. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular to bring justice for murdered and missing Indigenous women and girls across the country, should inform our discussion in this webinar and beyond. And obviously this is a unique time and a difficult time in our country, dealing with the aftermath of discovering 215 bodies of children buried by the Kamloops residential school, and also reflecting on the release of the report on the action plan for murdered and missing Indigenous women and girls. So this is obviously a unique time for us to have these reflections and think about our own personal and community plans of action. Next slide, please. So today's webinar, we're going to begin with a presentation from Professor Julie McFarland, and I'll introduce her in a moment. And we are very fortunate to have a distinguished panel who I'll introduce one at a time before they speak. That'll bring very special perspectives to the challenges of self-represented litigants in family court. And again, acknowledge that these webinars are funded through a grant we have with the Public Health Agency of Canada, who made these webinars possible across the country. Next slide. Before we start, just a reminder that attendees are muted during the presentation. If you have any special issues, please type them into the chat box. If you have a question, please use the Q&A box, and we're going to spend time near the end of this session with question and answers. There'll also be an evaluation link at the very end. And some of you who are getting continuous education credits, there'll be a certificate attendance generated and emailed to you once you complete the evaluation form. Presentation slides are posted on our website in English and in French, so you'll be able to follow along if you want. And there's a code of conduct that's in our chat function. And just a reminder that because these are public webinars that involve individuals across the country, that part of the code of conduct is not annoying, harassing speakers or making comments about speakers or bringing up the names of any individuals, partners, ex-partners, professionals you may have had an unhappy experience with. Our next slide. I'm pleased to introduce Julie McFarland. She's a distinguished professor emerita from the University of Windsor. She has researched and written extensively on dispute resolution, and in particular the role of lawyers in litigation. And she's also written extensively about self-represented litigants currently across the US and Canada, and she'll talk about this obviously in greater detail. It's estimated that between 60 and 80% of litigants going to family court are representing themselves. Professor McFarland is the director of the National Self-Represented Litigants Research Project, and there's a link to that project on our announcement with this webinar. And she's recently authored the book, Going Public, A Survivor's Journey from Grief to Action, published by Between the Lines in Toronto. Julie, welcome, and thank you very much for taking time to do this presentation today.
Thank you very much, Peter, and thank you very much to everyone else who is in attendance. I'm very happy to be able to address this subject with you, which is one of the many extremely difficult questions that we're facing in the legal system, given the volume of people representing themselves. And I just want to say as a starting point that my presentation is going to primarily reflect the research that we've done at the NSRLP and our experience with speaking with people who have self-represented while also dealing with family violence. So that's the source of the majority of the information and the data that I'm going to present to you, and also a study that I was peripherally involved in on this particular topic in Australia. But the other perspective that I think I bring to this is that I'm also a survivor of sexual violence myself, which is what my new book is about. And I have also participated in both the criminal and the civil process as a survivor. So I think that although I wasn't, thank goodness, self-represented in the civil process, I think that that has also given me some additional perspectives and some ideas and some clarity about the way that the legal system deals with sexual and family violence. So let's move on to the next slide, please. So just by the numbers, and if you don't mind, Eva, just click, click, click here. It's 3, yeah. Thank you. As Peter has already mentioned, we now have an absolutely enormous number of people coming to the courts without counsel. And if we focus simply on family court, in the larger centers, so for example, in Toronto, in Vancouver, and in Calgary, the numbers of people who are filing without lawyers is close to 80%, 80, which is incredible. And, bear in mind as well that we know from my own research and others that people who begin with lawyers often lose them over the course of proceedings. Approximately 50% of the people in my very large sample for the 2013 study began with a lawyer but ran out of money. And that number is replicated in the US study, the Northern Irish study, and the New Zealand study as well. So hard to believe, but that 80% therefore is probably slightly an underestimate. If we look at the courts across Canada, family courts across Canada, and we do a basic averaging out, it is now 50% plus coming without counsel. In the civil and appellate courts, depends very much, of course, on what area you're looking at, but the numbers are between 30 and 40%. That number is particularly, I think, interesting and has grown significantly in relation to appellate courts in just the last 5 years. And this rise is really exponential over the last 20 years. It's interesting to see that it does somewhat reflect and track declining legal aid, although, as I'm going to explain in a moment, that in itself no longer appears to be the sole solution to this issue. But very, very large numbers of people now without lawyers. In other words, it's more common to be on your own than with a lawyer in family court now. Next slide, please. And again, could you click through, please, Eva? Thank you. This is just to make sure that people are aware of the data sources for the 2013 study, which I'm going to be talking about. This study is available on our website, Representing Yourself Canada, along with everything else I'm going to mention today. Everything we do is free, open source, and downloadable, and the original study is up there. I did 283 interviews, a lot of interviews, with 259 self-reps, and some of them I did a little bit of a longitudinal piece and interviewed them twice. And of those folks, 60% were family litigants. It's always easy to look back on your methodology when you finish the study and wonder if you should have done something differently. One thing I might have done differently, but I had no idea what the response was going to be, was I might have just focused on family and not family and civil, as I did. I also had about 10% of the sample from administrative tribunals. But having said that, there was an astonishing similarity in the experiences which people reported, whether they were in family or civil court, no matter what the jurisdiction, and also in tribunals. Many people told me they were sure I would see enormous differences between jurisdictions and between subject matter areas. No, I did not. So of those respondents, 57% had an income under $50,000. So this was, not exclusively a lower income group. In fact, the socioeconomic demographics ended up, the detail of them being extremely similar to demographics across Canada. So in other words, pretty representative, slightly on the socioeconomic high side, but only very slightly. The other thing that was very interesting was that approximately half of the sample had a college degree, a college or university degree. And I thought, oh my goodness, that must be an overrepresentation, which you might expect with people volunteering to participate in research. But in fact, again, it was extremely close to the Canadian averages across the country. And as I have mentioned, they had 53% in that original study had previously or at some time retained a lawyer to help them. We have continued to collect some data on an annual basis from self-reps. We don't conduct full interviews any longer because we don't have enough time, but we have had so many people coming over the years since the project began asking to be interviewed that we have put together a self-complete intake form, and every 18 months we report out on that data. It's fairly demographic heavy, but we add additional questions all the time as different things come up as trends. So for example, we now have a question about seeking unbundled services or legal coaching services. And we're now seeing numbers of over 60% saying that they had previously or at some time retained a lawyer to help them. And I think this is really important because the point that it illustrates is that for most people, the natural thing to do still when they're faced with any kind of legal proceedings is to go hire a lawyer. There is not a mass mutiny going on out there where nobody will ever hire a lawyer again. Most regular Canadians know that they're going to need expert assistance, and they try to get expert assistance. The problem that so many of them face, however, is not qualifying for legal aid, not being able to pay the hourly rate for a lawyer, or being able to pay it, but only for a certain length of time before they've spent $25,000, $50,000 or more, and at that point they become self-represented. Next slide, please. Oh, sorry, last piece. Around half of 50-50 are male-female. There's no evidence to show that more men than women are self-representing. The numbers are fairly equal, and this is also the case in other jurisdictions. So most important point to get across is that by far the most important reason for increasing self-representation is lack of funds to pay for legal services. And again, Eva, if you'll just click through here, these are the various studies that have shown this now. Northern Ireland came out a couple of years ago, and that shows the same as well. And that doesn't mean it's the only reason. And I'm going to say a bit more about that in a moment, but it is overwhelmingly the most important reason. And let me explain something as well that I think is important for people to understand, which is that these were in-depth personal interviews that I did, in which I would spend 45 minutes to an hour in the original study with each individual. And I would ask them in many different ways to explain to me why they were now representing themselves. And it was obvious to me that in the first 10 or 15 minutes of those conversations, there was some reticence about talking about financial matters because, we're all somewhat shy of saying we can't afford something. It's still considered to be a little bit of a badge of shame. But by the end of those conversations, when I came back to the question again, why are you representing yourself? Would you have a lawyer now if you could afford to pay one? The answer was in virtually 100% of those cases, yes. And I think that it's important to understand that people often put up other reasons because they are less embarrassing. Well, I just think I know the most about my case. well, I just think, I had a lawyer and I didn't like that lawyer very much, and I think I can do it better. And I'm not saying that these are not important things to pay attention to. But I think when you give people the opportunity to really talk about their decision-making process and explain their choices, and the researchers in these other studies, all of whom I've been connected with, in fact, the US study was modeled on mine and I consulted to them, everybody says the same thing, that people overwhelmingly are representing themselves because they can't afford it. Next slide, please. So we probably all know on this call that in Ontario now, to qualify for family or civil legal aid, you have to earn less than $19,000 a year. That's a pretty minimal cutoff point. And as well, keep going, please, Eva. We know from Canadian lawyers' regular annual surveys that lawyers' fees, and obviously it depends on whether you're in an urban area, the level of seniority, but we're talking about $360 an hour on average, Canadian lawyer reports up. So that means that there's a very big gap between the people who are not covered by legal aid and the people who can actually afford to go on paying for a protracted period of time at this kind of rate or higher. Next slide, please. But there's also been a real change in public culture around legal services. And I think it's important to talk about this as well, because two other things have happened that have kind of converged with an increasing gap between those who are publicly assisted to get access to a lawyer and those who can genuinely afford that for anything other than a short period of time. And those two things are, first of all, there is a change in the way that people think about professionals. And we see this across professions. It's often described as a decline in professional deference. And people are much more inclined now than they were a generation ago to imagine, maybe I can do that myself. And we see this self-help mentality, which sociologists have a wonderful name for. They call it disintermediation, emerging in all kinds of different frames. So, for example, this is why people attempt to sell their houses themselves so that they don't have to pay a realtor's commission. This is why people sometimes, although I always think this is terrifying, manage their own savings and do their own investments instead of consulting a financial advisor, because again, they feel that if they cut out that middle person and do it themselves, they'll be saving money. And I think this is a combination of different factors, including increasing levels of education, increasing levels of I think some older professionals feel like declining deference is a lack of respect, but I think it's a different cultural shift than that. My parents would never have questioned the advice they got from a professional, a lawyer, a doctor, an accountant, whereas today's generation are much more likely to question that and to see that questioning as being a perfectly legitimate thing to do. So that in itself, I think, has changed the way in which we think about professional and also legal services. And the other thing that we're seeing, which has made an enormous difference to all of our lives, is access to information on the internet. These days when people go type their legal problem into Google, they'll see 100,000 responses. And quite a lot of self-represented litigants will tell you, well, I saw that and I thought, hey, how hard can this be? There's all that information out there. But once they actually get started, that's when they realize that this is going to be so much more overwhelming, so much more complicated, and basically so much more miserable than they had ever imagined it was going to be. Next slide, please. We do have a little bit of data. I thought I would share this with you because I know this is going to come up in relation to our discussions around family violence. And I think that there are some important assumptions out there that are worth, challenging a little bit and questioning a little bit. One of the things that we've been doing at the NSRLP for the last 3 years is we have been collecting data for a case law tracking project, which has been funded by a number of different law foundations and now the Social Science and Humanities Research Council of Canada. We're almost done. going back to 2013, looking at family cases in which there was a self-represented litigant that fell into one of our parameters. And I'm not going to go through that now, but if you'd like to look, there's a lot more information on the website. And a little while ago, we started to notice, and some of the students started to notice as they read these cases in order to analyze them, to put them into the database, that they were hearing a lot of very gendered assumptions being made by judges in relation to self-represented litigants. And I think what's interesting about this is, of course, if you're self-represented, there's no buffer. There's no counsel between you and the judge. And we certainly see across all family and civil cases, a lot more extemporizing, let me put that, by some members of the judiciary about the personal qualities of the self-represented litigant that they're seeing. This is not something, of course, that we would have ever expected to hear from a judge in relation to legal counsel, but it does seem to be entering into, if not the judicial reasoning, certainly the narrative of some of the decisions that are coming out. So we also noticed that there was a lot of difference between the characteristics ascribed to women, self-represented litigants in family proceedings, and the characteristics ascribed to men. The characteristics ascribed to men were mostly relating to aggression, forcefulness, bullying, that kind of thing. But we saw a number, and there's 6 little boxes here giving you, and there's a whole report if you want to read it too, examples of the way that we saw women SRLs being characterized by judges. And none of these words that I've used up here are our words. They're all words that come directly from judgments. Women as schemers, women as attention-seeking and dramatic, women as unreliable reporters of facts, women behaving emotionally, starting to feel familiar for any of us, women who expect to live off their husbands, and women who described as treating litigation like shopping, like a retail experience. That's come up a few times, that going to court is like going shopping and you're just going to pick what you want without really understanding how complicated it all is. So that's just a little aside. That's makes for a very interesting report if you'd like to look at it. Next slide, please. So why are people saying they can't afford to pay for a lawyer? Well, it's pretty obvious, really, for this person. They don't think they can do better. And this quote I use a lot because it's so classic of what we hear from people. I have no choice. It's not that I think I can do better. And the next slide, another good example. I chose to represent myself because I'm on a fixed income and I can no longer afford counsel. Remember, approximately half of people are in this group. I've now spent all my life savings and more on a 5-year divorce process. Next slide, please. Obviously, parties without expert assistance are going to face multiple additional challenges in the legal system. NSRLP has never been an organization that has recommended people to self-represent. We're trying to deal with the reality that that is the only choice left for many people now. But obviously, given that people are going to court without the expertise of training and simply the cultural understanding of what goes on in the legal process and in the courtroom, they are at a significant disadvantage. Interestingly, I had half a dozen lawyers in my original 2013 study who were representing themselves because they couldn't afford, and they were not people who normally specialized in the area they were representing themselves in, but they couldn't afford another lawyer. In other words, they couldn't afford themselves, which was somewhat ironic. And interestingly enough, their discussion of the emotionality and the difficulty, the emotional and mental difficulty of being invested in their own case and being their sole representative was some of the most poignant things that I heard. So I think that we need to accept that even for people who are very well educated and even for people who perhaps have had a lot of public speaking experience, being in court, speaking to your own case is a very emotionally draining experience. Next slide, please. We also know that outcomes are a lot worse. And we have more and more data all the time on this now. In 2016, the NSRLP did a discrete research study of summary judgments, because we were hearing from more and more self-reps who told us that they were being brought to court for summary judgment. They didn't know what was going on. Most of them, they thought they were coming for a hearing, and then they'd find it's over. So we went through CanLII for a couple of years, and we found all the cases in which there'd been a self-represented litigant on one side in a summary judgment, always brought by a represented side. And 96% of those summary judgments were granted, which is a quite amazing figure, really. Again, the report's on the website. Loom Analytics, one of the growing number of econometrics firms that are starting up, that are using data and publicizing data and presenting it to subscribers so that they can do their own research. From 2012 to 2016, just a little slice of data here in the Ontario Superior Court, 88% of self-reps lost motions applications and 75% at trial. We usually see people who actually make it to trial being better at what they're doing than the people who don't make it at trial, but 75% of them nonetheless lost. Next slide, please. So there have been a few studies in the United States, and these may be studies that Peter, you and your group are already aware of, looking at the impact of self-representation and lack of legal representation on family decisions. And this study by Kercin, one of the interesting things that it highlighted was that where there were parties coming without counsel in cases involving family violence, that the outcomes included significantly fewer protections. In other words, protection orders, no contact orders, and so forth. So it seems from that study as if it is in the same way as it's more difficult for self-represented litigants to access a positive outcome than someone who's represented, which you would expect, that this is also going to affect the number of protective orders that are put in place in cases involving family violence. Next slide, please. But that was a fairly discrete and smallish study. The study that I'm aware of that has gathered to date the most comprehensive data on the relationship between self-representation and family violence in family law proceedings is an Australian study, which was done out of the University of Sydney with a research team there whom I met with when they were first setting the study up and talked to them a little bit about methodology. I was there as a visitor at the time. And I'm going to spend the rest of my time today mostly drawing on their data, because we don't have data specifically at NSRLP, as I've explained to Peter, on family violence. And this, I think, is the newest and the most comprehensive study that is out there. But I think it also affirms and reinforces a lot of what I've already said about the disadvantages that self-represented litigants inevitably face coming to court without counsel. This study did 35 interviews with self-reps and 68 with family law professionals. They did a whole chunk of observation. When I was there in Sydney, they were actually putting together their observation schedule. And most of the people who they included in the study reported family violence. So this was not exclusively a family violence study. It was focusing on family proceedings, but most of the people who were part of the study did report family violence in some form or another. Next slide, please. And I think this is, an inevitable conclusion, and it flows very much from what I've already said, and in a way, it was what gave me the idea for the title of this presentation, Making a Difficult Situation Even Worse. Being a victim of family violence added a complex layer to self-representation. And this framed and shaped the issues that were the subject of the litigation and the environment in which the parties were litigating, so that the shadow of violence in terms of the needs of the parties, the fears of the parties of being around the other side, the fears that they would have perhaps for children in the family, their concerns about relocation, safe housing, and safety in the courtroom as well. All of these things added an additional dimension to what was already a challenging experience for them. Next slide, please. So there were particular things that the ANRO study has highlighted, and I think that this gives us, if you like, a kind of checklist of the problems that are out there to be solved. And a lot of these problems feel very intractable and very difficult. And I'm really looking forward to hearing what the justices have to say about this issue, and the family lawyer and mediator on our panel as well. Some of these problems do feel really, really intractable. It's tempting to think, why can't everybody just stop self-representing? But as I've said, that genie's not going back in the bottle. There are, I believe, ways in which legal services can be made more affordable to people. But for the time being, we know that there are these issues. First of all, completing documentation and presenting evidence. We know at NSRLP that one of the things that self-represented litigants find the most difficult is completing court forms. There was a dimension of my study that I reported on in 2013, which actually had, what I did was I had one of my research assistants. I heard so many complaints about the court forms from people in all three jurisdictions that I had one of my research assistants, who was a law student, who had already taken civil procedure and family law. I had her apply for a divorce in BC, Alberta, and Ontario. And I asked her to complete the initial forms for the court, to time herself, and also to keep a journal about what this was like. And initially, the student was absolutely thrilled to bits. She was terribly excited to do something so practical. But as I had somewhat feared, after a couple of weeks, she came back to me and she looked devastated. And she said, I just can't do these forms anymore. They're just so hard. And she did eventually complete the project. But I think the fact that somebody with training in law, knowing that they were doing this as a research exercise and not because it was something they were personally invested in, the degree of difficulty that she had, she's a family lawyer now, with doing the paperwork, I think, is very revealing. And again, that's all written up in that report. And this spills into the presentation of evidence. One of the things that we have known for a long time, and this comes up in the ANRO study over and over, is that self-represented litigants don't often understand what evidence is. What is evidence? What is relevant evidence? How would you need to prove something? In fact, our most recent NSRLP primer that we've just produced, co-written by Mr. Justice Clayton, Conlon Clayton, and Martha Campbell, who's a retired lawyer, is a primer on evidence that explains what evidence is, what it looks like, what evidence isn't, how you need to frame it, because this is such a consistent problem that we see and a difficulty faced by self-represented litigants. Something else that the ANRO study talks about specifically is inadequacies in courthouse protective services, about people, this was done pre-pandemic, people being very concerned when they go to the courthouse and they're going to be in the same room as somebody who has been abusive. And I think that one of the things that we're actually starting to learn a little bit more about in this pandemic year is that virtual hearings have some safety issues as well for family violence. I have talked to a number of not only self-represented litigants, but actually practicing lawyers in the last year who have been concerned about access to streaming of virtual hearings by former partners or stalkers or people who, they really don't want watching them. Now, technically, of course, those people could have all gone and sat in the courtroom and watched. But it's a very different thing to click on a link and watch something than it is to actually go to the trouble of going down to the courthouse. So in some courts, and I've worked with a couple of different courts on this, they now very explicitly give people the option to do audio only if they have personal safety issues, or if someone's worried about someone who might be watching, recognizing where they are and knowing where they are when they want to keep their whereabouts covered. So I think that both physical hearings and virtual hearings have safety implications that we haven't really quite sorted out yet for self-represented litigants in family violence cases. Next slide, please. So one of the things that we know from our own data and continuing in the intake forms that we receive from self-represented litigants is that of all the challenges that they face, the one that causes the most trauma, anxiety, and stress is actually appearing in the courtroom. One of the things that we have been really pushing at the project, and I think it's starting to make some progress with, is encouraging courts and encouraging judges, because they ultimately have discretion over this, to allow family litigants, self-represented litigants, to have a Mackenzie friend with them. In other words, someone who will not address the court, will not advocate, but will simply sit beside the self-represented person at the front table. So if it's somebody who is representing themselves and on the other side is their to-be former partner, and there has been some family violence, they can feel a little safer, a little calmer. The Mackenzie friend can take notes for them, whereas many people tell us that they leave the courtroom and they can't remember anything that happened because they were so stressed out. And that person can simply provide, a support and a debriefing resource for that person. We have been encouraging this. There are now self-represented litigants who will go, people who finish their cases, who will go as Mackenzie friends with the permission of the judge to sit at the front table with self-reps. We also, in our primer on Mackenzie Friends, explain who you shouldn't choose as Mackenzie friend, like your new boyfriend or girlfriend, perhaps. But it can be an incredibly worthwhile and useful support. And, we know from ANRONs as well that that challenge of actually being in the courtroom and facing someone who is an abuser, where there's been a history of abuse, is extremely traumatic for people. And I talk quite a lot about that and the additional overlay of trauma on standing up in court and speaking for yourself. In my book, Going Public, which describes my own experience of participating in 2 criminal trials where I had to testify. And I can certainly say that as a law professor and someone who's used to speaking publicly, that testifying in a situation where someone who has abused you is sitting 6 feet away from you is very difficult. And so that gives me a little bit more insight into what it would be like for a self-rep alone in the courtroom with somebody on the other side who has been abusive or violent to them. Of course, one of the things that has been an issue, and we're all aware of, I imagine, and ANRO's really focused on to some extent, was the whole issue of someone who is representing themselves and who is allegedly has been abusive or violent, then cross-examining the person who they have been abusive or violent towards. New South Wales in Australia was actually one of the very first places to bring in a prohibition. They amended their Criminal Procedure Act to prohibit a self-represented person in a family case from cross-examining the person on the other side. They have instead put in a procedure where an intermediary, or sorry, a person appointed by the court will do that cross-examination. So there can be no examination in chief, cross-examination, or re-examination in the New South Wales prohibition by the person who has been allegedly abusive, if this is a criminal matter, or in family court, there can be no cross-examination of the other partner. That certainly seems like a promising alternative. Of course, other courts are looking at the possibility of allowing testimony to be given at a distance or behind a screen, and various other approaches that we've sometimes used for juveniles and other vulnerable individuals. But I think that the ability of somebody to directly examine someone with whom they have had an abusive relationship is obviously a big problem here. Next slide, please. We know most of these matters are going to settle. So how in family proceedings is a self-represented litigant where there has been some history of family violence, how are they going to go about negotiating that agreement? And we know that self-reps are, in any case, anxious and concerned about being rolled over on a negotiation. I can't tell you how many self-reps have told me, and it's too bad that they have this fear, but it is a fear that they have, that if they go into a negotiation and the other side is represented, then they're going to effectively get taken advantage of, that the other side's lawyer will be much better at negotiating than they will be. Now, obviously, that only gets worse if there's some kind of history of violence that's making it more difficult for that person to feel really empowered in the negotiation. And there is a danger that people will give up money, will give up, for example, access to matrimonial property or pension rights in exchange for safety. And in some of my other research in the past in the family law area, I have certainly seen that as an outcome in negotiations where there has been a history of family violence, where people have traded money, things they're entitled to, for safety, for immediate safety. Another issue that ANROS looked at was that there is often a pattern of using litigation to continue to coercively control a partner in an abusive relationship. ANROS data shows that the majority of people who are facing continuous ongoing proceedings being brought back to court over and over again for custody and access variations, child support variations, the majority of those are being brought by women against men. And I certainly think from the instances that we've seen at NSRLP that there are many, many, many examples of litigation, in particular applying for variations, being used to continuously harass people following the end of the marriage. And this is in a way of weaponizing litigation against them. I know that we do have procedures for trying to ensure that there is a real basis for bringing an application for any kind of change in circumstances. But I can only tell you that there are many, many cases out there that I have come across where clearly the system is being abused by somebody who has been violent or abusive in the past and is now using a system of constantly bringing somebody back to court as a means of coercive control.
Julie, could I
yep.
just ask you to wrap up, because there's some
yeah, I think this is the last
great
one.
Okay.
Next slide, please.
Okay.
So these are the resources that I'm happy to direct people to. Representingyourselfcanada.com is our website, and I've mentioned many things you'll find on there. The ANROS report is available as well, the full report, and they've also written a number of journal pieces as they were developing the data before they published the final report. So a Google search will find you those. And the final piece on here is my new book that in part describes my experience of going through the legal process as a survivor of sexual violence. And that's the end. Thank you.
Thank you very much, Julie. And obviously there are some questions that I have that certainly relate to some of the last slides. So we'll get back to you for questions.
Hey, don't I get a congratulations? It's exactly 45. I
yes.
started.
Sorry, I meant to say that. Congratulations. Unusual for a professor to actually stay within timelines. Just before we move on to introduce the panelists, something I forgot to do at the outset, which I think would be helpful for the panelists, is do a quick poll so we know a bit about the audience, where they're from, and what brings them to this webinar. So Ava, with your support and indulgence, the first thing is, can you just indicate where you're joining us from? Obviously, which province, which area in Canada, the US, or other country? Just click right on your screen. So it looks like a majority of the attendees are from Ontario, but we have good representation from some of the other provinces, Atlantic and Prairies. Great. And next question, wanted to know in joining us, your interests. So are you currently or have been a self-represented litigant, lawyer, judge, social services, mental health, government, researcher, violence against women sector, specialized services for men? It says me, but I meant should be men, specialized services for men, and student. Hopefully only one person answers specialized service for me. Again, that should have been specialized services for men though. So it looks like we have a good cross section. Looks like the biggest group is violence against women sector and lawyers and a number of students. That's great. Thank you for sharing the poll results. And I'll move to the next slide and pleased to introduce the Honorable Mary Jo Nolan. Just by way of background, Justice Nolan was appointed to the Superior Court of Justice for Ontario back in 2005. She has a very interesting legal career in both private practice and working with the Ministry of the Attorney General, Courts Administration, Office of the Public Guardian. She was the first female master to be appointed in Ontario and the first female to be appointed to the Superior Court of Justice in Essex County. She retired from the court in 2014, but since that time, she's continued her work through mediation and arbitration services, providing services in Southwestern Ontario in family, estate, and civil matters. I also just want to mention that in going over her background, she's won 3 major awards recognition. In June 2017, the Law Society awarded her Doctor of Laws for her commitment over a career to access to justice. In May of 2018, she was awarded the degree of Doctor of Laws by the University of Windsor for her commitment to children and families as a social worker, lawyer, and judge. And in June, this month, she was given the Ontario Bar Association Award of Excellence for her work in alternative dispute resolution. So congratulations for those. And Justice Nolan, look forward to hearing from you.
Well, I'm very honored and pleased to have been asked to be a part of this important presentation on the increasing challenges for courts, counsel, litigants, both represented and unrepresented, challenges that are made even more difficult by the COVID-19 and its consequences. I'm especially pleased to be here with my dear friend, Julie McFarlane, who I've known for a long, long time, and whom I have great admiration and respect for. I'm going to focus my remarks on the challenges for judges, ensuring trial fairness and the impact on justice for litigants. Not long after my appointment in 2005, I attended a judicial conference at which 2 lawyers who were also medically trained gave a presentation about self-represented litigants. This was long before Julie started her important work. And as I look back on it now, it was so interesting to see how they characterized people that they were self-represented in the courts. As part of helping us to understand the particular needs of litigants who, back in 2005, were self-represented, they divided them into two groups. The first group they referred to as unrepresented litigants, and the second group as self-represented litigants. Their description of the first group of persons were those who were unable to afford counsel at the time of the court hearing and who wanted to know how to best conduct their case. The second group they referred to as self-represented litigants as persons who, while perhaps having financial means or not financial means, had other reasons for being self-represented, which they said were as follows. They had been represented by counsel in the past and they were not happy with the service they received. They also felt that they were correct in their position, which perhaps other counsel had not agreed with them on, and that they were confident in their position to convince the judge of the validity of their position and that they had the best chance of winning by representing themselves. By that time, I had conducted 7 trials in which one of the parties was not represented by counsel. I struggled with sorting out which of those I would have put into which category. In the majority of trials that I conducted in which one of the parties did not have counsel, that person was often the respondent. That was also very helpful for them in that they were able to observe the manner in which counsel presented their case and had a better understanding of what was expected when their turn came. At the beginning of the trial, I reviewed in detail with the parties in the courtroom, the steps in the trial, the order of witnesses, a little bit about direct examination, cross-examination, and when reply questions were allowed. I also explained about exclusion of witnesses and why that was important. Some of the most challenging aspects for parties without counsel is cross-examination and understanding its purpose and what some of the limits are, as well as the basis on which one can make an objection and the process for doing so. One of the rules I would emphasize was that any dialogue between the unrepresented party and the lawyer on the other side would be through me. Access to justice is a concept that we should all be focused on in all of its many meanings. Julie spoke a number of times about her presentation, about the concern about litigants without counsel. There's another aspect to that concept that bears mentioning. The last trial I had before my retirement involved 5 contempt allegations arising out of consistent violation of court-ordered access. The person against whom the allegations were made were acting on their own behalf. The allegations were quite straightforward, and the incidents themselves not seriously in dispute. The trial took 8 days. It should have taken 3. As I'm sure that both the case management judge and the trial management judge, the settlement conference judge, spoke to the respondent about the seriousness of the allegations and the need to consider retaining counsel for the purpose of the trial. At the beginning of the trial, I explained the nature of the allegations and again asked on the record whether that person wanted to retain counsel for the trial. The offer was refused, as I would have given an adjournment. The lawyer for the party had to charge his client for 8 days of trial as opposed to 3. If that lawyer had made all the objections to which they would have been entitled to make to the evidence and how it's presented, the trial would have lasted at least 10 days. The dilemma for counsel in that situation is whether to make the objections each and every time there's an improper question or a gratuitous statement in order to preserve the record in case of an appeal, or to only object to the most serious breaches and trust that the judge will only make use of the evidence that was properly presented. The access to justice issue arising from that trial was that the other three trials I was supposed to be hearing that week and the following week were not able to be heard. thus those people being denied their day in court. University of Windsor Law School has developed a program where students can take a course in assisting self-represented litigants in doing papers for court and so on. That's Dr. McFarland's initiative as well. And it's a very important class. Perhaps judges could also volunteer to present basic trial information to self-represented litigants. I think there are ways that we have to look to deal with this issue. And I think that it's going to take a lot of cooperation and a lot of understanding to be able to do it. But I agree with Dr. McFarland. It is the trend, and it is going to be more and more frequent in the future. So we need to be able to deal with the issue. Thank you.
There, I'm unmuted. Thank you very much for presentation. And again, there'll be lots of comments we're going to come back to. I'm now pleased to introduce the Honorable Linda Templeton. Justice Templeton was an educator before her career turned to law. She had taught French in the educational system at all levels, from kindergarten to second year university, and also taught English as a second language at the college level. So she could present in either language today, but she's choosing to present in English. As a lawyer, she worked for 5 years as a family law lawyer and 7 years as an assistant Crown attorney in Hamilton. Justice Templeton was appointed to and sat in Brampton for 3 years before she adopted her daughter from China and moved to London, where she presided until her recent retirement in May of 2021. So congratulations on a long, distinguished career. And I know the London courts are going to miss you, and I hope you come back in a different form, whatever judges come back as. I'll turn it over to you.
Thank you very much. I hope everybody can see me. I just see a blank screen right now. So if somebody can't see me, you can hear me and see me. That's
can hear
good.
You and see.
Okay. Thank you for this opportunity. I'm truly grateful. Some of my comments will be probably not particularly popular with the current system. However, I was appointed in '98, and these are observations I've made over the last 23 years as a sitting judge in both criminal and family court in particular over the last number of years. To say there has been an increase in the self-represented litigant process is an understatement. That it has exploded. It's particularly exploded in London, where I'm sitting now, and exploded all over Ontario. I think my view is primarily for financial reasons. The government is not anteing up on duty counsel or on legal aid. And I see that as a primary reason. There is also a reluctance. We have duty counsel here in London that are on call all the time whenever court is in session. There is a reluctance to go with duty counsel. And then finally, the third reason that has been my view, or I perceived over the last 10 years particularly, is that a lawyer is not needed. For the reasons stated by Professor McFarland. It's a self-help aisle, and they'll see what they can do on their own. I think before we look at how do we address this problem, my perspective is whether or not litigation is the appropriate forum for family law in the first place. And I think we have to start there. My view, it is not. I think that there have to be other ways other than the court system to resolve societal's, the nuclear families problems. And I think there should be more research into that as to what other countries are doing. with respect to diversion away from litigation. And I say that for a couple of reasons. One is I come from when we immigrated to Canada, my brother was medically ill. He was very ill. In the result of which he became very involved in medicine, became a specialist. And my family, my sister is a specialist in nursing. And so I have this medical people around me, professional people around me. And I often thought, if a patient is ill, they don't go in to emerge saying, this is what's wrong with me, this is what I want, by the way, I'm going to do it myself. So you have to look at, there's a reason for lawyers, and there's a reason they are trained, and to expect a self-represented to go in and come out with a successful outcome is very difficult. And here's why. One, there is a lack of knowledge with respect to the process, with respect regarding the rules in the civil procedure rules. I don't understand them half the time. I have to be reminded of what the rules say and what the rules allow. I cannot imagine going into an operating room and asking for a scalpel myself. And that's what we're expecting self-represented litigants to do. So there's a lack of knowledge regarding the process, so the rules, the civil procedure rules. Secondly, there's a lack of knowledge with respect to the applicable law. What's the best interest of the child? A lot of people don't realize that. Well, my child says this, so that she wants this or he wants that. So that's what their best interests are. Well, that's not what the law says. So that's the second deficit. The third one is, and this is huge, is the lack of knowledge regarding the rules of evidence. Never mind what evidence is, but there are rules of evidence with respect to what's admissible, what's hearsay, and so forth. There's a lack of understanding regarding the hierarchy involved in the judicial system itself. Judges only have so much discretion. So if you haven't pleaded, and this goes back to the first lack of knowledge area, if you haven't pleaded custody in your pleadings, I cannot give you custody at the end of the day. And I was telling my colleagues on a prior meeting we had about how I'd done a 6-day trial involving a self-represented lady who, it was lovely, she was great. And then I looked to the application, she wanted custody of children. I looked to the application, she hadn't pleaded custody because the expectations had changed through the process, through the litigation process. And so it had gone from access to custody. And here I was stuck because the entire case had proceeded along as if it was custody. And because the claims had not been properly pleaded, I was then procedurally stumped as to what could happen. So there's a lack of understanding regarding the hierarchy as well as to the other areas, knowledge of process, knowledge of the law, knowledge of rules of evidence. And then finally, there is a legalese. There's a language that is common to lawyers and to judges. We all don't know what proof beyond a reasonable doubt means. We all don't know what balance of probability means. And to expect a self-represented to understand balance of probability in a family law setting, or the assessment, how credibility, reliability of witnesses, those kinds of things, the assessment tools that the judge must rely on, to expect a self-represented to know those and be familiar, sufficiently comfortable with, to advocate for him or herself, I think is just unreasonable. And then finally, I find with self-represented, that the conundrum with respect to self-represented is the expectation as to outcome. Judge is not God. And judge can't resolve all your issues with your partner. you are going to have issues beyond the judgment. And I know that a lot of self-representatives have come back and said, I thought your judgment would resolve it. I can't. And that's actually, when I retired, when I made some comments, that was one of the hugely humbling factors of being a judge, was I couldn't resolve family law matters. They're not permanent. It's not a finding of guilt or not guilty. There's always an ongoing issue. And that's because of the social dynamic of family law, which gets me back to my first question, is whether or not litigation is the appropriate forum for family law in the first place. Further, since the onset of COVID, self-represented litigants have had this incredible difficulty at having access to technology. So access to computers, preparation and submission of electronic documents and so forth. So those are the issues that I see with respect to self-represented litigants. I've seen some questions as to, are they treated differently? Well, yes, in London, I'm proud to say I got involved with the preparation of handouts for self-represented litigants, which they're handed out at every settlement conference stage along the process, and then prior to trial on how to conduct a trial. I cannot be assured that self-represented A can read it, B, if they can read it, if they understand it, and C, even if they understand it, if they apply it. That's the problem. And the result of all of that concern and worry is that trials involving self-represented litigants are exceedingly long, and judges are constantly trying to step in but step out, ensure fairness, and protect the self-represented litigant from making blunders that they can't retract from. On the other hand, making sure that the represented litigant is also not penalized for having a lawyer. There's a family judges have a committee, and I can tell you now that this, I maybe shouldn't be disclosing this, but I just read this. It's been submitted by the post-COVID family law subcommittee. And I can tell you judges are exceedingly aware of the issues during the COVID and post-COVID for self-represented litigants. And I'll quote you some of the things they've said. There must be support available to litigants who do not have access to computers or tablets for any online attendance. The possibility of using some council rooms at the courthouse as Zoom rooms to allow litigants to connect to an appearance remotely is highly suggested. There needs to be better integration of duty counsel and mediation services and virtual court appearances if they are to function as substitute for in-person matters. At present, duty counsel rarely attends because they are not notified in advance. The mediation services are used only a fraction of the time compared to pre-pandemic. While there was initially a significant concern regarding the ability of litigants, particularly in child protection matters, to participate virtually, many judges have noticed an increase in respondent participation as litigants have not needed to travel to the courthouse to take time off work or arrange childcare. Some children's aid societies have assisted with technology for respondents to be able to participate virtually. And finally, there must be easily accessible assistance available to litigants who do not have the ability to provide electronic documents to the court. Court services need to treat this as an accessibility issue and scan for litigants who walk in with documents into the courthouse. And finally, any new case management software being considered for the court must support the ability of self-representatives to complete and upload documents easily. So finally, I shouldn't say finally, but there's another note. There needs to be more effective communication between the court and the self-represented parties who make up the vast majority of litigants in certain regions. In Ontario, self-representatives are often not aware of the changes to the court process, and there has been a marked downturn in the number of self-represented parties attending in court during the pandemic, which raises concerns about access to justice. What are the answers from my perspective? Something that I've advocated for a very long time are the following. One is the evolution One is the diversion of family law litigation or family law conflict out of the litigation process first. Try other areas of resolution first. Secondly is the establishment of a fixed triage system, the triage system being run by a judge to identify whether or not the pleadings are in order and have been correctly pleaded to achieve the desires of the litigant, the expectations of the litigant, should they be met by a court order. Also to determine whether or not the process is appropriate. And to explain the summary hearing matter, Professor McFarland alluded to the number of summary hearings that were granted and self-represented parties were not successful. That's because the issues can be decided on a summary hearing. The law is such now. The law was changed by a case out of London known as Heriniak. And there can be an assessment by the judge as to the success or not, or otherwise, and the merits of the case. And that is to, the purpose of that, part of that is to make sure that the process is streamlined.
Justice Templeton, I don't want to, if you want to finish that thought, because I want to make sure we have some time for questions at the end.
Good. Okay. So, and then finally, in my view, where there are, so creation of computer booths at the courthouse, and then finally, where there are allegations of violence involving a criminal offense, as Justice McFarland has suggested, there be no examination. And my practice has been to require written interrogatories rather than oral. Thank you.
Great. Thank you very much, Justice Templeton. I want to make sure we have some time for questions, and they seem to be piling up, and we will want to make sure we set aside some time at the end. I'm going to introduce Malcolm Bennett. And it's a good thing I'm introducing Malcolm Bennett, because I had a number of questions in the chat function about why we didn't have mediators as one of the important categories in our poll. Malcolm had a very busy practice as a family lawyer with Mackenzie Lake, and he retired from that, but he's continued his mediation arbitration practice as Blue Water Mediation. He's an accredited family mediator and elder mediator with the Ontario Association of Family Mediators, and currently serves on their board of directors. Welcome, Malcolm. We'll look forward to your comments, and I'm sure there'll be lots of questions about mediation at the end.
Thanks, Peter. I'm going to speak today about self-represented parties in mediation, and specifically about power imbalances and how we deal with power imbalance. It's a huge topic, and I'm not sure I can do justice to it in 10 minutes, so to speak, but in my practice, in my mediation practice for some 19 years now, self-represented parties represent probably in the range of 50 to 70% of my practice. So it's a considerable amount. And first of all, I'd like to share why, because I always ask, why are you coming to mediation and what your goals are? And inevitably, clients tell me that they're coming without lawyers because they want a process that's amicable. They want to maintain a relationship with their ex-spouse or partner. They want self-determination to be able to come to an agreement, but need a facilitator to assist them with that. They inevitably talk to me about the cost of lawyers and the fact that they don't want to spend that amount of money and expense to the detriment of their family. They want to move forward with their lives. They want a timely resolution, and so it's those type of reasons that they come to mediation. And knowing, and it's been mentioned that clients today have so much accessibility to information that they're becoming more aware of mediation. It's been around for some years now, and has really taken a foothold. when the lawyers tell me, when I do mediations with lawyers, that they're now in London handing out trial dates for 2023, you can see how that system just cannot address families' needs and interests on a timely basis. So when we talk of power imbalance, first of all, it's how do you identify a power imbalance? So in my practice, there's two ways. First, I send every client an intake form. And in the intake form itself, it's about an 8 or 9 page questionnaire, looking for information about the background of the relationship and sort of asking questions that they can answer that might raise flags about power imbalance, domestic violence, things of that nature. And that intake form is extremely valuable tool to use when I do my intake meeting with them. I have an intake meeting, lasts about an hour. I make sure that, and the purpose of that is, first of all, a mediator has to establish a rapport with the clients. And that's so very important because they're putting some trust in you and you have to show them that you're going to handle that trust in a proper manner. And so in the intake, parties need to know that it's totally confidential. You're not going to share the information with their partner. And that's extremely important if you want them to reveal to you anything that may be important about a power imbalance or domestic violence. I tell them that that is part of the purpose of the screening. But as we all realize, people aren't going to voluntarily perhaps tell you the history of the relationship and the bad things that have happened and the things that they've had to endure. It may be in the past, it may be something they're embarrassed about, it may be something that they just obviously don't open up to strangers about. So it's really a question of taking the time to delve into the past, the relationship. Also, I always make it an effort to talk about their extended family. There may be history in when they were being raised or whatever that's really important into understanding where they've come from. So taking the time to do a proper and full and complete screening is so critical and important if you're going to try and become aware of any power imbalance that you then have to deal with. I mean, people generally, when they come to mediation, they don't want to dwell on the past, they want to move forward. But in order to move them forward, sometimes you have to have them deal with the past and to talk about it. Sometimes they need to tell their story, and in mediation that can be done, but it has to be handled in a very skillful way. Once you've identified if there is a power imbalance, it's so important for a mediator to understand that you have to continue to screen throughout the whole process. It's not just that initial intake meeting. You have to screen through the whole process during mediation sessions, watching their behavior, their reactions, their emotions, all of that you have to take in and process in order to continually screen through that process to see how they're feeling. Once you've identified a power imbalance, you also have to consider, what is the nature of the power imbalance? Is it a personality conflict? Is it a financial imbalance? One party who just was never involved in finances, so it is a very awkward situation for them. Most often embarrassing. They're embarrassed to say, I should have taken more an interest in the finances, but I didn't know. There may be an imbalance due to guilt. They feel that they're the responsible party for the relationship breaking down. You have to know that in order that they're going to advocate for themselves in a fair and reasonable manner. Establishing that trust and rapport is going to give them the faith that they can talk in mediation if you create a safe space for them to talk and advocate for themselves. You have to be aware of imbalances that may be cultural, they may be relationship, they may be due to the roles that each played during the marriage or relationship. So there's so many different types of imbalances, and there may be more than one in any situation. So having a complete understanding of the parties, where they come from, their family, the reasons for the breakdown, and where they are at present is extremely important. And then you have to look at designing a process that's going to address that imbalance. The principle of a mediator is do no harm, and that's the key to rules. Everything that we do is just do no harm. So creating a safe space, and sometimes that is not even putting parties in the same room. Zoom has impacted the way we do mediations and the way we meet people and interview people. There's some good and some bad in my view. The Zoom certainly puts them in a safe place during the meeting. You know, you're not in the same room physically, so you don't have to worry about letting people leave or arrive at a mediation at different times, which we often do. So Zoom provides that level of security in some cases. In other situations, I find that it limits it in the sense when you have people in the room together and they're, you know, separated by a few feet across a table or whatever, the emotions can be felt, they can be real, and sometimes that's hard to have that come across in a virtual meeting. And those emotions coming across as real and raw sometimes may be very important to the couple breaking through the difficulties that they have, allowing someone to advocate for themselves, to tell their story. So I find that that's a bit of a limitation. I assume I see the people from the waist up, but often fidgeting with hands or their feet is important things to be able that I can observe when they're in person in a room. Hopefully we'll be back to that at some point in the future. So designing that process, if they feel that they're in a safe place, if they feel that the mediator is there to, a sense, to protect them from abuse, protect them from improper communication, they're much more likely to be in a better place to advocate for themselves. The other ways that I often will manage a power imbalance is assuring them right from the intake that the mediation process, any discussion that takes place is always through the mediator. So they don't get the idea that they're just arguing across a table. The mediator is controlling the discussion. They're the conduit through which that discussion takes place. Always asking them, do you feel comfortable? Will you feel comfortable in the same room? And then you explain how it will look. And sometimes they're just not, and you have to respect that. Controlling the communication is a skill that I think is developed with experience. Sometimes people need to vent, and that's not a bad thing. Sometimes they need to tell their story. Sometimes they need to tell the story before they can move on. I've had situations where people have done that, and you can see after that the level of anxiety just disappears, and the progress that we make thereafter is incredible. But you have to be careful as to type of communication, what it's about, how it's being presented, and certainly when to control it and when to stop it. Sometimes there's just bad communication and the mediator has to step in, stop it, relate the rules of mediation, how we talk to each other, and control it in that way. So it's an ongoing process, but if people feel that that's the role you're fulfilling, then they have the trust and they have the confidence in you to lead them through the process. It's always important to check in with them because you may feel that a mediation session went well, but they may go away feeling very anxious and stressed for some reasons. I emphasize to them, they have the ability to email me between mediation sessions and tell me how they felt. It's important for me to check in with them. How did you feel that the meeting went? Was there anything we could have done better? Is there anything we could have made you feel more comfortable? And they respect that, that you're there to look after them.
Malcolm, do you want to wrap up?
Yeah.
Sure.
So it is a long topic, and I only got through half of it. But let me just wrap up by having some closing remarks, and that when people come to me in mediation, they say, all I want is something that's fair and reasonable. And I feel that mediation can do that, because mediation you can always use as a triage. The word triage was mentioned, I think, by Justice Templeton. In mediation, we can direct people to social workers. We can get social workers involved. We can get therapists or counselors involved for the parties of the children. We can meet their expectations of being fair and reasonable and self-determination. The court has a very different role. The court is simply a decision maker, but if there's a power imbalance, that's going to continue. If there's domestic violence, it may still continue. It doesn't affect or address any of those things, which we can in mediation. And I think that that's why that breeds the success of mediation and why it is so successful. So thank you very much.
Thank you, Malcolm. And again, for the participants in this webinar, we're going to go a bit over time to make sure we can deal with some questions, and also make sure we hear from Julie Lee, who I'm going to introduce next. Julie Lee is a senior family lawyer at Millar's Law. After graduating from Western Law, she clerked at the Supreme Court of Canada with Mr. Justice Frank Akabuchi. She went on to maintain private practice and also has worked as review counsel at Western Law Community Legal Services, where she supervised and collaborated with Western clinical law students, offering family law representation to community clients. And she recently joined Millar's Law to lead the family law department, where she also assists in significant cases of public interest. Julie, thanks for being here, and please take your time. We're happy to go over a bit because people want to hear from you, and then we'll deal with some of the thorny questions that I see on the chat function and Q&A.
Okay, thank you, Peter. It's a pleasure to be here. I think those thorny questions are really pressing, and as a result, I will take my 10-minute and try to make it 5 minutes, because those questions from activists, I think, need to be entertained by our panel. The topic that I had identified, and I still will touch on, I've entitled my little presentation, How Survivors Lose Legal Representation, How Survivors Lose Lawyers, and identifying 3 hotspots. So I'll touch on each one of those 3 hotspots, knowing that at the center of the analysis is usually a woman, in 98% of the cases, presenting to a lawyer for legal services, and how, as Dr. McFarland has indicated, so many of those relationships tear apart and leave women by themselves in this very complicated legal system. I just want to say, because I don't think I'm going to have time to do this, how broken does this family law system have to be for us to fix it? As counsel speaking outside of court on an almost daily basis, we would say to each other as counsel, as lawyers, it's broken, it's broken, it's broken for years. And then the pandemic occurred, and I don't know how broken it needs to be for it to be radically changed. Okay, the 3 hotspots. The first hotspot that tears at the relationship that is so important and integral to legal representation is the impact of the abuse itself, the impact of the violence and the betrayal of trust. What I notice in my first meetings with clients, and my colleagues do as well, is that a lawyer has a job to do to poke at the case that's being presented to them, the potential evidence, and it's the value and the merit of that evidence, issue spotting, understanding what the client is asking, understanding whether the client is asking you something that the law can actually respond to, because as Justice Templeton has so beautifully pointed out, what's on the menu list in family law, in the litigation, in the legislation, is not at all often what we hear from survivors when they come to see lawyers. What survivors want is something very different. They want justice. They don't want equalization. They want fairness. They don't want to have to pay spousal support to their former abusive partner, et cetera, et cetera. So there's this real lack of synchronicity between what the task of a lawyer is doing in initially meeting and assessing how they can best serve a client as a lawyer and what a survivor is needing and asking for. And that tears on a real vulnerability that survivors have. Now, I'm not going to overstate this. On a case-by-case basis, it's not 100% common, but it is very common for the trust issues to be extremely fragile. That's 2 minutes. Yeah, between in a new and burgeoning lawyer-survivor relationship. And so to the extent to which a lawyer must press and poke at a case and ask nuanced questions, what that does is press against the survivor feeling judged, feeling not believed, feeling not supported, feeling like a survivor often does, that they're not believed and that their case is not going to be advocated to the most powerful extent of the law. And to the extent to which a good lawyer is always pushing and poking about that, that creates a possible fracture right at the outset of the relationship. The second, I have to move to the second hotspot, are issues that connect to the lack of trust and the feeling that connects to that around betrayal. And what more of a betrayal can there be than abuse by somebody in an intimate relationship? But I think I quickly mentioned this. I'm going to go back to it just for one moment, is the misalignment between expectations that a survivor has around what should happen at court, what should happen as an outcome of this case, and what a lawyer can actually deliver. That's really also tender ground in a new and burgeoning relationship between the survivor and a lawyer, because a lawyer's professional responsibility, and I'm not going to go on at length about the rules of professional conduct, is to assess the case competently and to transparently tell our clients the strengths, weaknesses, the bumps, the bruises, the warts, etc. And when we do that, many of our clients push back, especially those that are survivors, because they very, very much feel that you're not hearing them, which leads me directly, with 1 minute to go, I don't believe the irony of that, to the lack of time. So we've heard how expensive lawyers are. They are very expensive. Litigation is too expensive. It is not what we should be doing for families, and in particular children, which we've heard very little about today. But survivors deserve the respect, the time, the attention, the vigilance, the hearing of their stories. Doing that when it may cost them $1,000, 2 hours or 3 hours of a lawyer's time, is not appropriate. But many survivors will pay that because they haven't been heard. And if we circle back to the trust issues, it really touches on those fragile trust issues. If a lawyer says, quite appropriately, much of what you're saying is not relevant on this motion to change, a technical procedural issue that needs to be explained. So much of what you're saying is not relevant. And of course, the survivor is going to hear that as silencing and as pushback. So the current litigation system, the current procedural rules are not trauma sensitive, are not trauma informed, and need to be radically shifted. So I'll finish where I began. How broken does it have to be? There, I did it in 5.
Julie, thank you very much. And maybe I'll start off the first question with you, and if we get all the panelists back on screen together, and we'll start dealing with some of the questions, and then we may end up posting all these questions with some answers subsequently when we post this recording. So Julie, let me start with you. There's a number of questions that we've gotten before this webinar and listed here that sometimes abuse survivors feel they're pushed into mediation or parent coordination. you know, as Justice Templeton said, sometimes the family court isn't the best place to resolve some cases, and sometimes abuse survivors may feel pushed into alternatives where they don't necessarily feel protected. Any initial reflections on that?
I need to clarify, you're asking Dr. J or me? Dr. Julie or just me?
I'm asking, let me start with Julie Lee, because you gave up 5 minutes, and then I'll move to Dr. J.
I'm going to say that nobody should be doing anything in the legal process without having a full explanation, a transparent one, an accessible one in terms of language and time. That includes mediation. And so that's a choice. That is a choice, and it's a damn good choice in many situations, because there should never be anything like a 5-year divorce process, which Dr. Julie talked about in the first place. That's heinous, that's egregious, and it's particularly wrong where you have situations of violence between partners. So I'm saying that's a choice, and I think with professionals like Malcolm, and certainly with Justice Nolan, we can deal with this in a way that's even-handed, purposively. So as long as we're alive to the process and we're treating it realistically, that remains an option.
You know, you're not dealing with necessarily lawyers preparing cases, you're dealing with abuse victims, potentially alleged perpetrators. Are judges prepared enough to deal with those dynamics?
It's a very difficult question. I was appointed 23 years ago, so I don't know what the answer is now as to the training. It's just something that we've learned as we've gone along, because it was not, you know, it wasn't an issue 10 years ago, 10, 15 years ago. Mary Jo, I don't know what your experience is.
Well, I think the example that I gave of how self-represented litigants were described in 2005 in a very, you know, chop kind of thing. It's this and it's this, and that's kind of what you have to do. I think that your idea about a triage system is a fantastic one. I think, like you, that the court is not the place to deal always with family law, but there's nothing else. And for the immediate future, people are still going to be going to court. So I think we have to look at how we can make the court more friendly, in the sense of people not getting, like your example of getting to the trial and find out they hadn't even pled what it was that they were seeking for. So that triage, I think, is a marvelous idea. And so a judge, instead of doing case conferences, would do triage on some of these cases. I think that would be an enormous assistance. And then some programs in centers where there are law schools or there are universities, to have programs like Windsor has been trying to do, to be able to assist self-represented litigants and just doing simple things like doing the proper papers and things. It's a huge problem, and not very many easy answers, unfortunately.
Another question about whether it's actually safe for a self-represented litigant alleging abuse to actually go to court against a self-represented abuser, alleged or otherwise. So, I mean, that's a challenge. Are safeguards in place today?
Absolutely.
Okay.
Certainly for physical safety, the person probably most at risk is the staff member or the judge. There are 10 times out of 10 there are court constables either in the courtroom or just outside.
Malcolm, just a quick comment from you. Anything you have to do to, you know, knowing, obviously you're doing some screening when you start mediation to make sure it's case is appropriate. Are there safeguards? I guess it's different during COVID than.
It is, but generally speaking, I would say in 90% of my cases, I have the parties as a practice come at different times, leave at different times. I give the party a chance to come early. If I'm somewhat concerned, I have them leave first. or leave second, but I time it. Many cases, I think, Peter, the parties are still living in the same house when they come to mediation, right? So you have to deal with a safety plan in those circumstances as well.
As someone who has been part of a court process, as someone who has also been a victim of violence, I can tell you that simply saying we're going to put the physical things in place and that's the end of the issue, aren't we good, is completely overlooking the fact that the whole system is traumatizing, intimidating, and overwhelming for people who've been through any kind of violence and who are continuing to live with the consequences. So I'm sorry, but congratulating ourselves because we're able to put physical safety in place does not get to the systemic issues and the fact that the system still doesn't really recognize or affirm people who have trauma.
If you had one wish, if you could wave a magic wand and improve things for self-represented litigants. I know you have a long wish list. Templeton went over a whole bunch of things that she read from her report. If you had one thing you could do that would have an immediate impact. Justice Nolan?
I think one of the things that we've benefited from over the last couple of years are the programs, the MIP programs that allow, ones that are done well, that allow people to understand a little bit about the family court system. I think it would be wonderful to have a program like that for self-represented litigants, where they could attend and have their questions asked, and it be staffed by possibly social workers and lawyers, and also people who focus on kids, because I certainly agree with Julie Lee that the center of all of this are the children who are involved. And it's a lot of things to pay attention to.
And Justice Templeton, give you the final. I know you had a really good wish list of things from the report you read.
My wish, foremost wish, is triage for the system, and from thereafter education, going both ways, and so far as the team approach goes.
Great. Well, I want to thank Dr. J, Dr. McFarland, for her presentation. I want to thank the panelists for a very lively discussion. I mean, all of you brought very different perspectives and experience, and I really appreciated the time and thought you put into your presentations. There will be recording available of the webinar a couple of weeks down the road. And the one thing I will try to do, there's lots of good questions that we didn't get to, and I'll get a list of the questions. I might circulate them to all the panelists to see whether you have some thoughts about answers. Obviously, they're not case specific, general answers, and we'll post them on our website. So again, thank you all very much.